Is your DEI program, as implemented, illegal discrimination? Can a white man sue for discrimination based on race and gender? I'm Karen Michael. You're listening to The Job Judge. Welcome to The Job Judge, where we navigate through all those legal landmines and workplace dysfunction that I'm pretty sure is happening in your organization. I'm Karen Michael, your host of The Job Judge. I've been an employment lawyer for 31 years, a former HR executive. I wrote the book, Stay Hired, How to Thrive and Survive in the 21st Century Workplace, and I'm in your workplaces every single day doing investigations, training, and workplace advice. Together at The Job Judge, we are going to make workplaces work. Now, a couple ground rules. Nothing I say on this podcast is legal advice. It's just general guidance. And also sometimes what we talk about on The Job Judge could be triggering. So let's talk about DEI. DEI stands for diversity, equity, and inclusion. Some organizations have justice, diversity, equity, and inclusion. They refer to it as JEDI. And in case you haven't noticed, DEI has been getting a bad reputation lately. It's because it's been hijacked by people that want to make it about firing all the white men and replacing them with women and people of color. If you look at just some headlines on some articles right now, Axios in January of this year, companies are backing away from DEI. Washington Post, 2024 might be do or die for corporate diversity efforts. Here's why. Inc., diversity policy backlash drives cuts to DEI staff. Inc., how to avoid a DEI disaster like MS Society just had, terminating a 90-year-old volunteer with 60 years of service in the name of diversity and inclusion. Look, here's the problem. Some people really have done DEI wrong. DEI was never meant to be an affirmative action program. That's not what DEI is about. DEI is really about making sure that you have the tools you need to be successful in your job. It's about not looking at the golden rule, what I would want. It's about looking at the platinum rule. What would you want? What would make you successful? It's truly about inclusion and belonging. But some companies didn't get the memo. And that's frankly why we can't have nice things in DEI anymore. But let's talk about this case that came out of the Fourth Circuit Court of Appeals in March of 2024. There's this guy named David Duval who worked at Novent Health. And in his job, he allegedly was doing a great job. He was very successful in his job. He's a white man who began working there in 2013 when Executive Vice President and Chief Consumer Officer Jesse Curitan, a black man, hired him as Senior Vice President of Marketing and Communications. And he held that job the entire time that he was at the company. The evidence at trial showed that he performed exceptional in his role, received strong performance reviews, gained national recognition for himself. Despite all of that, Curitan, his manager, fired him in July 2018, a decision, according to the case, that came as a shock to both Duval and his colleagues. Novent Health, a multi-billion-dollar company with tens of thousands of employees and extensive human resources department, had no record of any documented criticism of Duval's performance or reasons for termination. Immediately after firing him, Novent Health elevated two of his deputies, a white woman and a black woman, to take over his duties. It then later hired another black woman to permanently replace him. Believing that he was fired merely to achieve racial and gender diversity, or more specifically, to hit diversity targets within its leadership, Duval sued his former employer under Title VII of the Civil Rights Act, which prohibits discrimination or harassment based on race, gender, national origin, color, and religion. The case proceeded to trial, and he won. He actually won $10 million in punitive damages, as well as front pay, back pay, and other types of pay. Now, on appeal to the Fourth Circuit Court of Appeals, the court actually reversed the punitive damage award and said there was not enough evidence for punitive damages. But it kept the jury verdict, and it kept his award for other damages. And the case is, I think, a very important example for corporations that are implementing these DEI programs to understand what the rules are. Because the rules say you cannot fire people in the name of DEI to achieve some sort of equity in your organization. What's relevant is what the D&I plan was about. This case talks about how in 2015, the company hired a woman, Tanya Blackman, to be the Senior Vice President of Diversity and Inclusion and develop an inclusion strategic plan. That plan had a 3-phase approach. Number 1, phase 1, learn and engage, where they're going to assess Novent Health's D&I culture, benchmark its levels, and seek to get the board and leadership to commit to using D&I in decision-making. Phase 2, develop and influence. They would set goals to embed diversity and inclusion in 3 to 5 years with a commitment to, quote, adding additional dimensions of diversity to the executive and senior leadership teams and establishing a system-wide decision-making process that includes diversity and inclusion lens. And the 3rd phase would evaluate their progress. In November of 2016, Blackman, who had since been promoted to Executive Vice President and Chief Diversity Officer, presented this business case, and it established a timeline to develop metrics to intentionally integrate D&I in 2017, to evaluate those metrics in decision-making and get approval. By February of 2018, just months before this man was terminated, the body responsible for overseeing and implementing the D&I plan included Blackman, Curitin, Duval's boss, and Duval. He was on the D&I committee himself. At the meeting, the D&I Council discussed various models for measuring the success of their efforts. They met in May of 2018, just before his termination, continued their discussions, and looked at demographic data. And the demographic data showed a decline in female leaders from 2015 to 2017. It also showed that while 87% of the workforce was female, only 4% of the workforce comprised of Novent Health's leadership. It also revealed, quote, a higher representatives of whites among leadership versus the workforce. We got too many white people around here. What are we going to do with all these white people? That's kind of how it sounds. Conversely, the data reflected that African American representation in management decreased at each level of management with the exception of the executive team. In October of 2018, shortly after Curitin terminated his employment, the D&I Council met again, and minutes from their meetings talked about how their members should reflect our communities, our leadership should reflect team members. All of the communication showed a question of whether they were looking at quotas. They did say that in addition to offering suggestions, they're not interested in meeting quotas. Quotas are mandated by someone outside of your organization. We want to reach out our targets. So targets, not quotas. What's the definition? What's the difference? And then after he was terminated, they presented a report showing their great success in using qualitative and quantitative data as drivers to measure and track progress. It indicated that they made progress in increasing Black and African American representation in leadership roles, but they still had a gap in Black leadership as compared to industry benchmarks. So they were clearly measuring success is more Black individuals and women. Failure is too many whites. I mean, that's basically what this read. And so this case went to trial. And what the court talked about is what the jury found. And this is what the court said. The jury, because one of the things that was interesting is the reason that he was terminated, according to his boss, was they were going in a different direction. And then when he questioned the termination, they told him that, well, the reason was because you didn't do well in some presentation like a year or two earlier. But then when Johns Hopkins called to get a reference, Curitin gave Duval a glowing review. So this is what the court said. In upholding the jury verdict, the court said this. The jury heard evidence that Duval performed well in his role, but was nonetheless fired and replaced at one point or another by 3 women, 2 of whom were racial minorities, amid a substantial D&I initiative that called for remaking Novent Health's workforce to reflect a different racial and gender makeup. And it also heard conflicting and uncorroborated reasons why he was terminated. Viewing all of this in the light most favorable to him because he won the case, they could not conclude that the only conclusion they could have reached was in favor of the employer, which was the test on appeal. There was more than sufficient evidence for a reasonable jury to determine that race, sex, or both motivated Novent Health's decision to fire him. The point is age, race, gender, national origin, color. It's not just the only factor. It can't be a motivating factor. That's the problem. If they're motivated by somebody's race or gender to take an adverse employment action, that's illegal. Now, what I think is the most important part of the case is in the footnote. This is what the court said in the footnote. To be clear, employers may, if they so choose, utilize D&I type programs. What they cannot do is take adverse employment actions against employees based on their race or gender to implement such a program. The evidence presented in this trial was more than sufficient for a reasonable jury to conclude that that is precisely what Novent Health did to Duval. Corporations, you're getting some bad advice from some people who are telling you that these programs are legal. And there is no question that we need D&I now more than ever because our workplaces are so divisive and so toxic. We need people to work together in a collaborative way, and the only way we can do that is to make sure people bring their best selves to work every day and that they're safe, not just physically safe, but psychologically safe. So the problem is we need D&I now more than ever, and people are removing those programs because for the last many years, employers have been getting some really bad advice from people who are trying to commit illegal misconduct in the name of diversity. And this was especially prevalent when Mark Cuban, y'all know him, he's the Mavericks owner, he posted on his social media about hiring people. And one of the things he said, he posted it on X, and he said, quote, race and gender can be part of the equation, but he's never hired anyone based exclusively on race, gender, religion. So his statement that race and gender can be part of the equation when he hires people got the eye of the EEOC Commissioner Andrea Lucas, the Equal Employment Opportunity Commission, that federal agency that enforces federal employment discrimination, and she responded to his post. Can race-sex, quote, be part of the equation, quote, for an employment decision as long as it isn't the but-for factor? Generally, no. Title VII uses motivating factor liability. This isn't an opinion. Reasonable minds can't disagree on this point. It's the plain text of Title VII. So too often we've thought, well, if that's not my only reason, as long as, it's but-for causation, no, it's motivating factor. So what I want to encourage employers to do is to look at your D&I program. Make sure that it's about inclusion and belonging and respect and helping people to use all the tools that they have to be successful in your organization. And please stop with any kind of quotas, targets, or tying manager pay to their diversity goals, because what you're really saying is, how many of X do you have? You're saying representation. That's what you're saying when you're talking about diversity goals. So this case, I hope, which was upheld by the Fourth Circuit this year, I hope that this is a wake-up call to some employers not to get rid of your D&I programs, but to make sure that they work appropriately for all employees. Now it's time to ask the job judge. Every week we answer a question that's out there, and then I'll be the judge of that. This week's job judge is this. And by the way, if you want to ask me a question on the job judge, I might just answer it right here on the podcast. You can email me at Karen@thejobjudge.net. That's Karen@thejobjudge.net. Here's the question. Is it normal for an HR professional to scour someone's Facebook to look for questionable material to terminate them? My current HR director complains about so-and-so in their Facebook feed, none of which is questionable. For example, employee had a death in the family. She scoured his Facebook page for when he posted the obituary. Is this normal or acceptable behavior? I know you can be terminated for certain posts or questionable behavior, but to seek something out just to get someone terminated, ? Well, I'll be the judge of that. If you're posting something on social media, it's free game. So understand that's the rule. Now, should employers be scouring for no reason social media posts of employees? That seems like a big waste of time. There really is no reason to go be scouring somebody's social media posts. But if the HR person is concerned, I wonder if this person really did have a death in the family. They have every right to go look for what there is publicly available. So yes, employees can be terminated for what they post on social media. That doesn't sound like the case here. It sounds like this person's frustrated that HR is somehow going through other people's social media pages, and it feels like maybe an invasion of privacy. But as long as something is publicly available, then that person has every legal right to look at social media posts that are publicly available. Now, am I happy about the fact that the HR person is going around sharing things like gossiping? No, I think that's completely unprofessional. Someone in their role in human resources needs to maintain professionalism and confidentiality. And so if he or she is doing that, that person should be doing that in the course of a legitimate reason and keeping that information confidential. Now, we drop a podcast every single week. You're not going to want to miss an episode. So be sure to subscribe, like, follow, comment, so that no one misses an episode of The Job Judge. I'm Karen Michael, and you've been listening to The Job Judge.